Well, mahalo, Councilmember Bolton. It's good to be back. Last time I was here, that was 2019, and 3 presentations were actually given like every other month. A lot has happened. A lot has happened. And it has gotten very serious. And that's the update that I was asked to give, right, on the current status of Hawaii under international law and the impact that it has on all of us. Okay. I'm also a senior lecturer in political science and Hawaiian studies at the University of Hawaii. I teach courses on this. In fact, I teach a graduate course, Introduction to the Hawaiian Kingdom, a 600 level course in the College of Education graduate program. So teachers that are coming back for their masters or their PhDs, they take my class. And what always happens is 3 weeks into the class, they all realize they're teaching the wrong history, and they start to readjust their curriculum, okay? Now, I'm a graduate of the Kamehameha schools back in 1982. After Kamehameha, I went on to a military college, New Mexico Military Institute in Roswell, New Mexico, where I got my commission as a second lieutenant in the Army Reserve, part of the early commissioning program, where they put 4 years of military science into 2 years because they needed officers, right? I finished there in 1984 with my commission and my associate's degree in pre-business, transferred to UH, got my bachelor's, and I had signed a contract, 3 years active duty, 3 years reserve. I began to serve my time in the Army National Guard to fulfill my requirement, and then I spent time on active and reserve until I eventually became a captain after 10 years. My last command was Battery Commander, 105 Howitzers and Mono Deuce. I come from a very military standpoint, and I took that mindset into the university system, where I entered the university to get my master's in political science, specializing in international relations and law, and then my PhD, okay? And I can tell you that the information that was being presented in my doctoral research shocked a lot of people. It shocked them. In fact, I had the dean of the law school on my doctoral committee, Aviam Soifer. I had Neil Milner as a chair of my doctoral committee. He's the political pundit you see on KITV News. His background is law and judicial behavior. Had 2 other political science professors, public law, sovereignty, and had John Osorio on my doctoral committee from Hawaiian Studies. Also had a dean from the University of London Law School on state sovereignty and international law, Professor Matthew Craven. And they couldn't refute anything in the paper. The last person to sign off on my doctoral dissertation was Avi Soifer. And he was going through it with a fine-tooth comb. And he finally signed off on it, and that's where I got my PhD. In fact, John Osorio told me, he says, Keanu, you know everything in your doctoral dissertation just undermines everything we teach in Hawaiian studies. I said, that wasn't my intent, but I can see that. Right? My purpose was to successfully defend my dissertation from my doctoral committee. And it worked. Since then, I've been teaching classes. Multiple dissertations and master's theses have come out from all over the world on this issue, and it is spreading, and that's what you're going to see. So here's an update: status of Hawaii under international law, accountability for war crimes, which was the last presentation that I did in 2019. So what we have here, first of all, is the false narrative, okay, that concealed 131 years of an American occupation. In 1898, this narrative begins in 1898, the Hawaiian Islands were incorporated into the territory of the United States. In 1946, the United States reported to the United Nations Secretary General that Hawaii was a colonial possession under its administration since 1898. A colonial possession is a territory that is not a country of its own. And in 1959, the United States reported to the UN Secretary General that the people of Hawaii exercised their right of self-determination and chose to be the 50th state of the United States. And currently, Hawaii serves as headquarters for the Indo-Pacific Combatant Command of the Department of Defense, with 118 military sites throughout the Hawaiian Islands. Hawaii's history under international law didn't begin in 1898, it actually began in 1843. So So in 1843, November 28, both Great Britain and France jointly recognized the Hawaiian Kingdom as an independent state. The following year, on July 6, the United States President John Tyler recognized also the Hawaiian Kingdom as being independent. And that's important. So for the first time, Hawaii is a full-fledged member of the community of states. And if you notice the flag of the Hawaiian Kingdom, which is flying today, called the State of Hawaii flag, it has the Union Jack on that flag. Okay, the Union Jack goes back to Hawaii being a British protectorate since 1794, where Captain Vancouver entered into an agreement with Kamehameha I. And that is when Hawaii became British. In 1843, it was the British that recognized Hawaiian independence. And by 1893, Hawaii had over 90 embassies and consulates throughout the world. So here, I've established the fact that Hawaii was a country, okay, an independent state. It's irrefutable. Well, as a country, under international law, it is called a subject of international law. So we need to understand what happened in 1893 through the lens of international law. Well, according to Judge Greenwood from the International Court of Justice, traditional international law was based upon a rigid distinction between a state of peace and a state of war. Countries were either in a state of peace or in a state of war. There was no middle ground, okay? It's like being hapai. You're not half hapai. You either pregnant or you're not. Same thing. So when I was in the Army, okay, during war, we call that the law of armed conflict. That's the Hague and Geneva Conventions that apply. But if we're in a country during a state of peace, like in Korea, South Korea, then that is governed by the Status of Forces Agreement. That's a treaty, okay, and Korean law. So that's what that means. Now, acts of war committed by the military force of countries against another country, that is called an act of war. That triggers a state of war. So when Russia invaded Ukraine, that fact of the invasion was the act of war that triggered a state of war. And those are the rules that apply to that situation called international humanitarian law. Also in the Army or military, they call it the law of armed conflict. And a state of war includes military occupation. So on January 16, 1893, the Hawaiian Kingdom was invaded by United States Marines and its government overthrown and replaced by a puppet government the following day, calling itself the Provisional Government. Queen Liliuokalani conditionally surrendered to the United States and called upon the president to investigate the actions taken by U.S. troops and the American ambassador. What is important is she did not surrender to the Provisional Government, because the Provisional Government was set up by the U.S. ambassador. Now, by direction of Queen Liliuokalani, President Cleveland, on March 11, 1893, initiated a presidential investigation into the overthrow of the Hawaiian government. On December 18th, 11 months after the overthrow, the president reported to the Congress his findings and conclusions of his investigation. He told the Congress on the 16th day of January, 1893, between 4 and 5 o'clock in the afternoon, a detachment of Marines from the United States steamer Boston with 2 pieces of artillery landed at Honolulu. The men, upwards of 160 in all, supplied with double cartridge belts, filled with ammunition, and with haversacks and canteens, and were accompanied by a hospital corps with stretchers and medical supplies. This military demonstration, he concluded, upon the soil of Honolulu, was of itself an act of war. That is significant. That is the president saying that, right? He acknowledged January 16 triggered a state of war. This civilian government in 1893 was the Hawaiian Kingdom governmental infrastructure, because all that was replaced by the U.S. military through their insurgents was the Queen and her cabinet. Everyone stayed in place, and they were forced to sign oaths of allegiance to the new regime that the U.S. Marines were protecting. Now, that governmental infrastructure of 1893, January 17, is today the state of Hawaii. Okay? It's a direct successor of that governmental infrastructure. Under international law, the military overthrow, and this is very important, the military overthrow of a country's government does not affect the continued existence of the country called a state, along with its independence and sovereignty. That is important to know. As Professor Brownlee explains, After the defeat of Nazi Germany in the Second World War, the four major Allied powers assumed supreme power in Germany. The legal competence of the German state, its independence and sovereignty, did not, however, disappear. What occurred was akin to legal representation or agency of necessity because they were administering German law, but they were foreign countries doing that, the foreign militaries. The very considerable derogation of sovereignty involved in the assumption of powers of government by foreign states without the consent of Germany did not constitute a transfer of sovereignty. So although the Nazi government was overthrown, Germany was still intact as a country, subject to the law of occupation. Now this is something that I understood firsthand because in 1990 I was at Fort Sill, Oklahoma going through officers advanced course as a captain, a field artillery captain. And we were there when the first Gulf War broke out. Saddam Hussein invaded Kuwait. And we're getting live intel coming in. And we knew even though Saddam Hussein drove the Kuwaiti government that he overthrew into Riyadh in exile, Kuwait was still Kuwait. Nothing changed. 1 week later, Saddam Hussein from Baghdad declares unilaterally that Kuwait is the 19th province under Iraqi law. That didn't change anything. Our job was to expel the Iraqis and get the Kuwaiti government from Riyadh back into Kuwait. The same thing would apply here. What was overthrown in 1893 was not the country, it was the government. So we have the Hawaiian state recognized in 1843 as an independent state, and it had a government, a constitutional monarchy called the Hawaiian Kingdom government. And that government, admitted by the US president, was illegally overthrown. But that overthrow did not equate or did not affect the Hawaiian state. It still existed. Now, the US did not establish a military government to administer Hawaiian Kingdom law, as they have done in all military occupations since the birth of the United States. And instead, unilaterally seized the Hawaiian Islands in 1998 during the Spanish-American War by passing a law called a Joint Resolution of Annexation. That's exactly what Saddam Hussein did. Okay? The Congress claimed that the annexation by a congressional joint resolution, is on the records, was a military necessity in order to fight the Spanish in Guam and the Philippines. The problem is, whatever justification you have, it's still illegal. That's without the consent of the Hawaiian Kingdom. Now, congressional laws, however, have no effect beyond the borders of the United States. And according to the United States Supreme Court, which explains this, says that neither the federal Constitution nor the congressional laws passed in pursuance of it have any force in foreign territory. And operations of the nation in such territory must be governed by treaties, international understandings and compacts, and the principles of international law. That's pretty straightforward, because that's how it is. In fact, congressmen and senators during the debate in 1898 were saying the same thing. You cannot annex a foreign country by passing a law. And they said, no, we can because we're at war. That's how they justified it. But the justification of it doesn't make it legal. I'm sure Saddam Hussein was trying to justify why he wanted to annex Kuwait, because he said they actually own the oil fields. Now, according to the Handbook of Humanitarian Law in Armed Conflicts, annexation is illegal. Now, this is a term that is important to understand called annexation. Annexation is not a process, but rather an outcome of a process. Okay? You have to have something transferred, called ceded to you, and then as a result of the cession by a treaty, that property is annexed, or that territory is annexed. That's why the term annex is used with buildings. Annex 10, it's an extension, right? That didn't happen because annexation. It happened because there was an authority for that building of that, the construction of that building to take place, right? So, you need a treaty. Well, the international law of belligerent occupation, therefore, must be understood as meaning that the occupying power is not sovereign, but exercises provisional and temporary control over foreign territory. The legal situation of the territory can be altered only through a peace treaty. International law does not permit annexation of territory of another state. You cannot just say, I got you. You need to acquire it. It's like somebody claiming I own property in Wailuku. You cannot just claim it. You got to show a deed that you got it, right? That's how it works. Well, there is no peace treaty, and the occupation continues now at 131 years. Now, why has it lasted so long, right? And we're going to get into that. There's actually a very good reason why we didn't know. So, through the lens of international law, what is American laws being imposed in a foreign country, whether it's the Hawaiian Kingdom, whether it's Kuwait, whether it's Iraq, whether it's Iran, Mexico? What is that? Because it's unlawful. It's called usurpation of sovereignty. So usurpation of sovereignty is the unlawful imposition of the municipal laws and administrative measures of an occupier over the territory of the occupied state. Okay, that's usurpation of sovereignty. In 1919, the United States and the other Allied powers of World War I determined that usurpation of sovereignty during military occupation is a war crime. The U.S. admitted that's a war crime. During the First World War, the United States and the Allied powers charged that Bulgaria ousted Serbian law in the Kingdom of Serbia, courts and administration. Taxes were collected under Bulgarian fiscal regime. Serbian currency was suppressed and Serbian public property removed or destroyed. This is what they were referring to as a war crime in the First World War. Also, that Germany and Austria suspended Serbian laws and substituted for their own, especially in penal matters, in procedure, and judicial organization. After World War I, they began to look at prosecuting individuals for war crimes that were identified from World War I. Now, Judge Blair of the American Military Commission in Nuremberg, established to try Nazi war criminals, stated with regard to usurpation of sovereignty that this rule is incident to military occupation and was clearly intended to protect the inhabitants of any occupied territory against the unnecessary exercise of sovereignty by a military occupant. Well, since 1898 till today, the United States did exactly what Germany and Bulgaria did in the First World War. The United States unlawfully imposed its municipal laws, administrative measures, and taxes collected under the American fiscal regime over the territory of the Hawaiian Kingdom. Where the First World War only lasted 4 years, usurpation of sovereignty during military occupation of the Hawaiian Kingdom is now at 131 years. In the Hawaiian situation, usurpation of sovereignty during military occupation also serves as a source of the commission of secondary war crimes under customary international law, which include compulsory enlistment, which is drafting, denationalization, pillage, destruction of property, deprivation of a fair trial, because the courts have no authority in a foreign country, American courts, deporting civilians of the occupied territory, sending them to prisons in America, and the transferring of populations into occupied territory. Those are war crimes, but secondary war crimes that stem from usurpation of sovereignty. Now, in order to conceal the military occupation of an independent state, the United States clearly, and when I say United States, I'm not saying all of America, I'm saying the administration at that particular time. In this case, was McKinley, right? The United States deliberately implemented a policy of denationalization through Americanization in 1906. So this is my tutu's generation, my grandparents' generation, when they were young children. Now, denationalization is the obliteration of the national consciousness of the occupied state in the minds of school children. You cannot remove the national consciousness in the minds of adults. You can't. Right? Well, Pol Pot tried that in the killing fields, but it didn't work. But you can obliterate it in school. And that's exactly what the Germans were doing in occupied territory. In 1919, the United States and other Allied powers of the First World War also determined that denationalization is a war crime. And the Allied powers of the First World War charged that Bulgaria imposed their national characteristics on the Serbian population, banned the Serbian language. People were beaten for saying good morning in Serbian, and the Serbian population forced to be present at Bulgarian national ceremonies. Now, the United Nations War Commission in Nuremberg to try war criminals stated, Attempts of this nature, denationalization, were recognized as a war crime in view of the German policy in territories annexed by Germany in 1914. At that time, as during the war of 1939 to 1945, inhabitants of an occupied territory were subjected to measures intended to deprive them of their national characteristics and to make the land and population affected a German province. You cannot accomplish that without having time. 4 years could only show the attempt. 131 years, nearly complete. Samuel Damon, one of the lead insurgents in Hawaii, he stated in 1895, if we're ever to have peace and annexation, the first thing to do is to obliterate the past. That's in the records. He was also a trustee of the Kamehameha schools at that time. And I can tell you, as a Kamehameha graduate, I wasn't taught any of this stuff. And Hawaii Kamehameha schools became the flagship of brainwashing. It did. Sorry to all the alumnus. Denationalization is also a crime against humanity and cultural genocide, as Professor William Shavis, leading expert on international criminal law, wrote in a legal opinion for the Royal Commission of Inquiry on war crimes being committed in Hawaii. So in 1906, here's a pamphlet titled Program for Patriotic Exercises to be used in the schools, both public and private, put out by the Board of Education. The theme of the program was to indoctrinate the children, the school children of the Hawaiian Islands, to be American and to speak English. The history that they were taught was America came in 1898, and everything you're going to learn prior to 1898 is American history. Nothing about the Hawaiian history. And you couldn't speak Hawaiian. And if you did speak Hawaiian, you were severely disciplined. And those stories are still there. Harper's Weekly magazine did a story on this. They visited 3 schools, Ka'iolani Public School, Kahumanu Public School, and Honolulu High School, before the name was changed to President William McKinley High School in 1907. Here they are. The reporter takes this picture of 614 school children at Ka'iolani Public School. And at the command of the principal, they all salute the American flag. And the caption says, at the command of the principal, they yell with unison, we give our heads and our hearts to God and our country. One country, one language, one flag. This scene shows a salute to the American flag, which flies on the grounds of the Ka'iolani Public School, which has many Japanese pupils. Why would they throw Japanese in there? Because the takeover of Hawaii to build it up as a military outpost was to protect the West Coast from possible invasion by Japan. That's on the record. And it says here that this drill is constantly held as a means of inculcating patriotism in the hearts of the children. That's my grandparents' generation. By the time I got to my dad at St. Louis, second generation, it's already institutionalized. By the time it got to me at the Kamehameha schools, out of sight, out of mind, I didn't know anything. I went to New Mexico Military Institute to become a commissioned officer. And here's a quote from Dresden James, a British novelist that seems quite appropriate. He wrote, when a well-packaged web of lies has been sold gradually to the masses over generations, the truth will seem utterly preposterous and its speaker a raving lunatic. Did you know when I first came out with this information back in the 1990s, people thought I was a lunatic? Welcome to lunacy. Now I back it up with a doctoral dissertation and law review articles. Yeah. So, facing with this situation, how do you deal with it? Because I am currently a battery commander, first of the 487 Field Artillery, that can be activated at any point going to war. My unit went to Afghanistan, Iraq, World War I, World War II, Korea, Vietnam, yeah. And I was in combat arms with the infantry as a battalion fire support officer. In fact, I served with Major General Hara when he was a young lieutenant at the 2nd Battalion, 299th Infantry out of Hilo. We went to Korea for a military exercise that was called Team Spirit, right? So the only thing that I had to address this problem was my military training and my military experience, right? So military approach to a military problem. This is what the map should look like regarding Hawaii as an occupied state. That's how it should look. Okay. There's some pictures of me as an officer. In the bottom left is I'm in Hokkaido, Chitose, battle exercise, and that's a picture with the Japanese Defense Force. So in the military, especially as officers, really only as officers, especially at the captain level, 03, you are trained in what is called an estimate process, called the command estimate process when you're dealing with a situation, right? So the command estimate process is basically to frame a suitable operational plan. The military commander must make an estimate of the situation because before I can look at what I can do, I needed to assess the situation, do an estimate. And I'm not angry. I'm chiseled as a refined Army officer. I'm just looking at the facts. That's all I'm looking at. So an estimate of the situation involves a careful consideration of all the circumstances affecting the problem. In making this estimate, he considers his mission. Mission is to comply with the law of occupation. All available information of the opposing force, OP4, considerations affecting his own command, and the terrain insofar as it affects the situation. What's the manpower? What kind of unit we got? What weapons do we have? How many people we have? You know, all this comes into play. So, the terrain here, though, is not jungle warfare, desert warfare. It's called international law. That's the terrain that I got to master, because I got to know how to maneuver on that terrain, which I was not trained for, but I'm going to get trained on it. For over a century, the United States has not complied with international humanitarian law, also called the law of armed conflict, in its prolonged occupation of the Hawaiian Kingdom. Compliance with the law of armed conflict will bring the occupation to an end. It's inherent in the rules. It is. So the mission that I came up with, through all legal means, compel the United States and the state of Hawaii to begin to comply with international humanitarian law and the law of occupation. That's the mission. Okay. So first, we have to restore the government, because without a government, the state can't talk. And it's been silent for over a century. Now, according to Professor Rim, the state continues to exist even in the factual absence of government, so long as the people entitled to reconstruct the government remain. And that is an issue of nationality, not race. Nationality in the kingdom, multi-ethnic, but they were called Hawaiian subjects. So even Sanford Doe, he's Haole, Caucasian, but he was Hawaiian. We use that word wrong today. We make it like it's a blood quantum thing. That's an American law, which is usurpation of sovereignty. Doesn't apply here. On February 28, 1997, Hawaiian subjects exercised their right of internal self-determination and took the necessary steps to restore the Hawaiian Kingdom government as a regency under the doctrine of necessity and Hawaiian constitutional law. The doctrine of necessity, we're trained in the Army. Anybody in the chain of command that is taken out by an artillery round, that person, whether a private or sergeant, has to assume the chain of command up to that captain. And he's called the acting captain until a properly commissioned officer comes and releases him, then he goes back down. Until then, it is his duty to assume the chain of command in order to maintain the command structure. That's how it works. That's how we've been trained. They also apply that in government. You can assume a position in an acting capacity, but you still are vicariously liable for your actions in that capacity. That's why in the Army, a lot of privates don't want to become a lieutenant. Yeah? But whoever had the seniority, you take it or you get court-martialed. That's how it works. What's important is a regency serves in the absence of a monarch. It is not the monarch, and it is a provision under the Hawaiian Constitution, Article 33. Now, addressing over a century of occupation, the Hawaiian Council of Regency was formed similar to the formation of governments in exile during the Second World War under the doctrine of necessity. In particular, the Hawaiian Council of Regency was established in similar fashion to the Belgian Council of Regency after King Leopold was captured by the Nazis. They fled to London, formed the government in exile. As the Belgian Council of Regency was established under Article 82 of its Constitution of 1831, the Hawaiian Council of Regency was established under Article 33 of the Hawaiian Constitution of 1864. I'm sure you folks can realize how very much I'm rule-oriented. That's my military side. Rules have to apply. Without it, you got chaos. So we have to come up with a strategic plan to address this. And the strategic plan has to be broad enough so that tactical maneuvering can take place. But the strategy is still intact. Phase 1. Three-phase operational plan. Phase 1, verification of the Hawaiian Kingdom as an independent state and a subject of international law. This is an important part of the strategy because we need some outside body, some international body to confirm the Hawaiian Kingdom still exists. Not me keep saying it. Not me citing a historical record. Not me citing a law. We need some international body. We don't know who or what that would be at that time, but that is phase 1. We got to get past that. Once we get past it, then we go to phase 2, exposure of Hawaiian statehood within the framework of international law and the law of occupation as it affects the realm of politics and economics at both the international and domestic levels. Phase 2 will focus on individual accountability and compliance to the law of occupation. This is where it's going to get very uncomfortable. Very uncomfortable. And the fact that you are getting uncomfortable during phase 2 proves my point. It's real, because if it was frivolous, you wouldn't be uncomfortable. Okay. And then naturally phase 3 will be when the occupation comes to an end by a treaty of peace. So, phase 1, completed. Permanent Court of Arbitration in the Netherlands verifies the Hawaiian Kingdom is a state, current state. So the Permanent Court of Arbitration was established in 1899. The United States was part of the establishment of the Permanent Court of Arbitration under the Hague Convention No. 1 for the Pacific Settlement of International Disputes. The purpose of this court to be established as an intergovernmental organization that would form tribunals to resolve disputes is so that countries don't go to war. If they can't resolve their dispute, then you go to war and use the rest of the Hague Conventions, Hague Convention 2, 3, 4, to regulate the war. That's codification of customary international law. So the Permanent Court of Arbitration has what is called institutional jurisdiction. It is set up to resolve disputes among members who sign the treaty that form the court, because they yearly contribute to the maintenance of the court. So they can enter the administration of their dispute without costs. But Article 47 of that treaty allows non-contracting states to also use the facilities to resolve an international dispute, right? But they have to pay for the administration fees, right? So here, the first thing that the Permanent Court of Arbitration has to do is to make sure that at least one of the parties is a state, because that makes it international. Private people can't go there to resolve a commercial contract dispute. So they can form a tribunal after they verify that, in this case, a dispute between two states. And here's from the record of the Permanent Court of Arbitration. From the case repository, we got Ecuador versus the United States. In 2011, you have a treaty dispute between these two countries. They verified Ecuador to be a state and the United States to be a state. It was after this that they formed the arbitral tribunal to resolve the dispute. Okay. Next is a dispute between a state and an international organization. And this is a dispute between Ecuador and the United Nations. Okay. And they identified Ecuador as a state and the United Nations as an international organization. That is when they formed the tribunal, the ad hoc tribunal. And then we have a dispute between a state and a private entity. And that case was Larson versus the Hawaiian Kingdom. Okay, Larson versus the Hawaiian Kingdom. Began in 1999, it ended in 2001. According to the case description there, you're going to see it covers everything, pretty much what I shared with you earlier. So it says here that Lance Paul Larson, a Hawaiian subject, who's a resident of Hawaii, brought a claim against the Hawaiian Kingdom by its Council of Regency that on the grounds that the government of the Hawaiian Kingdom is in continual violation of the 1849 Treaty of Friendship, Commerce, and Navigation with the United States, as well as the principles laid down in the Vienna Convention on the Law of Treaties of 1969, the principle of international comity for allowing the unlawful imposition of American municipal laws over him within the territorial jurisdiction of the Hawaiian Kingdom. What they did was They accepted the case that we have war crimes being committed by imposition of American laws that led to Lance Larson's unfair trial and incarceration on the Big Island. And here, they identified Lance Larson as a private entity and the Hawaiian Kingdom as a state. Okay. So phase 2 is going to be initiated, exposure. We got the verification by an international body that is reputable. And the United States made an agreement with the Consular Regency in the Netherlands from their embassy in The Hague if they could access all records and pleadings, and we entered into that agreement. So they not only recognize the Hawaiian Kingdom continuing to exist, but also the Consular Regency as its government, its provisional government. So phase 2 was initiated by exposing the Hawaiian Kingdom during oral hearings on December 7, 8, and 11 in The Hague.
The dominion of the Hawaiian Kingdom. In a summary, from 1840, the Hawaiian Kingdom possessed a constitutional government with elected and appointed officials and a complete system of civil and criminal laws to govern Hawaiian territory. On April 8, 1842, King Kamehameha III in Privy Council commissions 3 envoys to secure international recognition of Hawaiian independence. And these individuals are Timoteo Ha'alilio, William Richards, and Sir George Simpson. On December 19, 1842, Hawaiian envoys secured United States President Tyler's recognition of Hawaiian independence. November 28, 1843, the British government and the French government formally enter into a declaration recognizing Hawaiian independence. In our pleadings, we refer to that as the 1843 Anglo-Franco Proclamation. From that point, Hawaii has had its statehood recognized as being independent. As such, it began to enter into these treaties: Austria-Hungary, Denmark, France, Germany, Great Britain, Italy, Japan, Netherlands, Russia, Spain, and the United States of America. International recognition is evidence that the Hawaiian Kingdom had diplomatic representatives as of 1893 from those countries, as far as consulates and embassies. Rather, what we find is that the United States has never expressed itself as an occupier. Who would? They will never admit to occupation. But yet, to admit to occupation is in a sense to admit to the continued existence of the Hawaiian Kingdom as an independent state, which is really the crux of the matter, which is actually what is holding up, you might say, this issue to be resolved. Thus the legal order, thus the reestablishment of the government, thus the relationship between its nationals.
I mean, to be slightly unkind, but thus the issue in rem. The point is that if the Hawaiian Kingdom continues to exist, its existence is in rem. It's not in personam. The Hawaiian Kingdom doesn't exist solely in the opinion of Mr. Larson.
Right. But that existence should not be dependent upon an occupier, because you basically put the occupier on an equal footing with the Hawaiian Kingdom in its own territory. So really what needs to be addressed is what came before the occupation, whether the statehood or whether the legality or illegality of the Hawaiian Kingdom, not the illegality or legality of the United States as an occupier. Should the tribunal find it has jurisdiction, we are prepared to submit an offer of proof. We felt that this tribunal would offer some clarity so that for the first time we have a third party to present these type of merits that can be scrutinized by international law, rather taking it before a United States tribunal which could not rule on it to the detriment of itself. So in that sense, there is really no other way to address this issue. And the opportunity did arise because it was Mr. Larson who was adhering to Hawaiian Kingdom law. And if the United States was adhering to occupation, not whether they're illegal or illegal, but if they were adhering to the laws of occupation, we wouldn't be here right now.
So it shows I was actually there. And I served as the lead agent, meaning I ran the legal team of the Hawaiian Kingdom Council of Regency. Now, after the oral hearings were held at the Permanent Court of Arbitration in the Netherlands, the Council of Regency was called to a meeting by Rwandan Ambassador Dr. Bio Zagara in the city of Brussels, Belgium, on December 11, the day after the last day of the hearing. So our legal team met with him, and he stated to us that he was at the Permanent Court of Arbitration the previous Friday, and that his government in Kigali became aware of the Hawaiian Kingdom case. What caught his eye was, what is the Hawaiian Kingdom doing in the World Court? He went to the registry to get all the records, because we made it public for not just the United States, but any country. We're going to be transparent. At this meeting, he said his government had offered to the Council of Regency to report to the United Nations General Assembly by placing it on the agenda, the prolonged American occupation. And that is when I had to excuse myself from the meeting with my legal team. I said, we need to talk. After careful consideration, the Council thanked the ambassador of Rwanda's offer, but it could not accept the offer in good conscience because it needed to address the devastating effects of denationalization first. Here we are in the World Court, the Permanent Court of Arbitration. The amount of people that know that Hawaii is occupied and it's an independent state, I can probably count them on two hands. We have to address the fact that nobody knows it back home. And we're not going to move from one mountain to another mountain when nobody and everyone back home have no clue what's going on, right? So what we're going to do, we're going to look at what's going to guide us on our approach, how we're going to deal with this denationalization. So in U.S. Army Field Manual 27-10, the Law of Land Warfare, it says remedies for violation of international law, war crimes. In the event of violation of the law of war, the injured party, the Hawaiian Kingdom, may legally resort to remedial action of the following type. We're going to adopt that. Publication of the facts with the view to influencing public opinion against the offending belligerent. That is our approach in phase 2. Since returning from the Netherlands in 2000, the Council of Regency addressed the devastating effects of the war crime of denationalization by having me enter the University of Hawaii Political Science Department and graduate program to acquire a master's degree and a PhD degree specializing in international relations and law with research focus on the Hawaiian Kingdom and the occupation and how to bring it to an end. That's why I went back to the university to get my master's. I didn't just arbitrarily say I'm going to get my master's degree on this. And I don't have to prove the kingdom exists. It's already verified. I got to explain why it exists, and political science can do that. It is in the university system worldwide where we will institutionalize, not politicize, the Hawaiian Kingdom's continued existence through international law. This has nothing to do with the Native Hawaiian sovereignty movement. Yeah? That's based on a false aspiration of becoming independent. No, Hawaii is an independent state, but it's occupied, and rules have to be followed. In 2003, the Hawaiian Society of Law and Politics was established at the University of Hawaii that encouraged multidisciplinary research on the subject of the Hawaiian Kingdom and the American occupation. And these are some of the publications. And these publications included master's theses, doctoral dissertations, law journal articles, peer review articles, publications. So it's no longer just the Council of Regency saying it, but we did ignite it, and it spread. The most recent publication that is going to be coming out this summer is Oxford University Press is going to publish a book titled Unconquered States. Non-European powers in the age of imperialism. I was asked to be the author of the chapter on the Hawaiian Kingdom, and that's coming out this summer. Oxford University Press. That kind of gives you the level of where this is going, or where this is at. Also in 2017, the National Education Association, that's the largest union of school teachers and administrators in public schools, Hawaii State Teachers Association is an affiliate member. They sent delegates to Boston for their conference in 2017. And these delegates, because they teach about Hawaii being occupied, because they're learning it in our classes, They got the resolution passed that says the NEA will publish an article that documents the illegal overthrow of the Hawaiian monarchy in 1893, the prolonged illegal occupation of the United States in the Hawaiian Kingdom, and the harmful effects that the occupation has had on the Hawaiian people. When the delegates got back, they contacted me and asked if I could write those articles for them to be published on the NEA website. And the first one was published 2018. The illegal overthrow of the Hawaiian Kingdom government, followed by the U.S. occupation of the Hawaiian Kingdom, and the impact of the U.S. occupation on the Hawaiian people. Okay, so you can see that this exposure is gaining traction in academic circles, right? It's not a political issue. This is just accurate facts, right? Now, this growing body of academic research also garnered attention outside of Hawaii. United Nations Independent Expert Human Rights Council in Geneva. The National Lawyers Guild, United States. And two non-government organizations, two NGOs that have consultative status with the Human Rights Council, International Association of Democratic Lawyers and the American Association of Jurists. On February 25th, 2018, this letter was sent from Dr. Alfred Desires from the United Nations Human Rights Council. He's what is called the United Nations Independent Expert. And he stated in this in this letter, that as a professor of international law, the former secretary of the UN Human Rights Committee, co-author of the book, The United Nations Human Rights Committee, Case Law, 1997 to 2008, and currently serving as the UN independent expert on the promotion of a democratic and equitable international order, I have come to understand that the lawful political status of the Hawaiian Islands is that of a sovereign nation state in continuity, but a nation state that is under a strange form of occupation by the United States, resulting from an illegal military occupation and a fraudulent annexation. As such, international laws, the Hague and Geneva Conventions, require that governance and legal matters within the occupied territory of the Hawaiian Islands must be administered by the application of the laws of the occupied state, in this case the Hawaiian Kingdom, not the domestic laws of the United States. All he's citing are the rules that apply in any occupation, right? In December of 2019, the membership, nearly 6,000 members of the U.S. National Lawyers Guild, a progressive bar association, adopted a resolution that immediately called upon the United States to begin to comply with the law of occupation and administer the laws of the occupied state. And then, following this resolution, the National Lawyers Guild sent a letter to Governor Ige on November 10th, 2020. Dear Governor Ige, State of Hawaii, the National Lawyers Guild, the oldest and largest progressive bar association in the United States with 70 chapters and more than 6,000 members, calls upon the State of Hawaii and its county governments as the proxy of the United States, which is in effective control of Hawaiian territory, to immediately comply with international humanitarian law while the United States continues its prolonged and illegal occupation of the Hawaiian Kingdom since 1893. On February 7, 2021. Now, this is all events that occurred after my presentation in 2019 to the Council. On February 7, 2021, the IADL, International Association of Democratic Lawyers, they also adopted a resolution. And the IADL is made up of organizations like the National Lawyers Guild in America, well, other organizations, legal organizations of lawyers in other foreign countries. They come under the International Association of Democratic Lawyers. And they passed a resolution calling upon the United States to immediately comply with the law of occupation. On February 16, 2022, the International Association of Democratic Lawyers and the American Association of Jurists sent a joint letter to all members of the United Nations General Assembly in New York City and Geneva, drawing attention to the American occupation. And that's a copy of that letter that was sent to the embassies of all the countries that are members of the UN, seated in both New York and in Geneva. On February 26, of that same year, 2022, the IADL and the AAJ registered with the United Nations Human Rights Council to deliver an oral statement on the human rights violations that are currently taking place as a result of the American occupation. Both the IADL and the AAJ asked me to deliver that oral statement to the Human Rights Council on March 22nd.
Thank you, and I now give the floor to International Association for Democratic Lawyers.
The International Association of Democratic Lawyers and the American Association of Jurists call the attention of the Council to human rights violations in the Hawaiian Islands. My name is Dr. David Keanu Sai, and I am the Minister of Foreign Affairs ad interim for the Hawaiian Kingdom. I also served as lead agent for the Hawaiian Kingdom at the Permanent Court of Arbitration from 1999 to 2001, where the court acknowledged the continued existence of my country as a sovereign and independent state. The Hawaiian Kingdom was invaded by the United States on 16 January 1893, which began its century-long occupation to serve its military interests. Currently, there are 118 military sites throughout the islands, and the city of Honolulu serves as the headquarters for the Indo-Pacific Combatant Command. For the past century, the United States has and continues to commit the war crime of usurpation of sovereignty under customary international law by imposing its municipal laws over Hawaiian territory, which has denied Hawaiian subjects their right of internal self-determination by prohibiting them to freely access their own laws and administrative policies, which has led to the violations of their human rights, starting with the right to health, education, and to choose their political leadership. What I presented to the Human Rights Council was war crimes being committed as a result of usurpation of sovereignty. I just basically put all that information on them, right? Now, part of what we're doing is exposing, right? We're bringing it out because that's going to trigger responsibilities. It will, and we're going to get to that. Now, in 2005, the UN World Summit endorsed the definition of the responsibility to protect that contained 3 pillars. The first pillar identifies states as the primary institutions charged with protecting their population from war crimes and genocide. The state is responsible. I'm with the government of an occupied state. Second pillar empowers the international community to encourage and help states to exercise this responsibility, because war crimes cannot be derogated. That is the highest level of customary international law, called a peremptory norm. It's a jus cogens. And the third pillar calls for collective action in a timely and decisive manner through the Security Council when the state fails its responsibility to protect. Well, the Council of Regency acknowledges the first pillar. It has to investigate war crimes. And the last time I was here in 2019, we were in the process of creating the means by which to investigate war crimes and to bring perpetrators to make sure that they get held accountable. Now, a potent check on abusive power by the occupying state is international criminal law and war crimes. It's a potent check. According to the International Committee of the Red Cross Study on Customary International Humanitarian Law, states must investigate war crimes allegedly committed on their territory and, if appropriate, prosecute the suspects. This rule that states must investigate war crimes and prosecute suspects is set forth in numerous military manuals with respect to grave breaches of the Geneva Convention, but also more broadly with respect to war crimes in general. April 17, 2019, the Royal Commission of Inquiry was established. And that's what I presented in 2019 here to the Council. I was designated as the head of the Royal Commission of Inquiry, and Professor Federico Lanzarini from the University of Siena, Italy, Professor of International Law, is the deputy head. So it says here that the purpose of the Royal Commission of Inquiry shall be to investigate the consequences of the United States belligerent occupation, including with regard to international law, humanitarian law, and human rights, and the allegation of war crimes committed in that context. So that's the mandate of the Royal Commission of Inquiry. Article 3 provides the composition of the Royal Commission of Inquiry. So the composition of the Royal Commission shall be decided by the head and shall be comprised of recognized experts in various fields. Everything we do is based upon merit, not politics. Merit. So you might say the Council of Regency is based upon meritocracy. It also will apply to the Royal Commission of Inquiry. So the Royal Commission of Inquiry has acquired legal opinions from the following experts in international law. Professor Matthew Craven, University of London, SOAS, School of Law, on the subject of the continuity of the Hawaiian Kingdom as a state under international law. Also, Professor William Shabis from Middlesex University, London, School of Law, on the subject of the elements of war crimes committed in the Hawaiian Kingdom and that these elements have to be met in order for criminal culpability to take place, prosecution. And Professor Federico Lanzarini, University of Siena, Italy, Department of Political and International Studies, on the subject of human rights violations in the Hawaiian Kingdom and the right of self-determination. Of note is the reputation of Professor Chabis at the United Nations. He is a foremost authority on international criminal law and war crimes and genocide and crimes against humanity. He's a heavy hitter. He's also involved with the International Criminal Court. They advise. He wrote the legal opinion on war crimes being committed in Hawaii. So denationalization, usurpation of sovereignty, destruction of property, he covers the elements. And a primary element to fulfill what is called the mens rea, the guilty mind, is you had to have been made aware of the factual circumstances of an occupation of a state. Once you have that, and you do something that is a war crime, that actus reus can be coupled with the intent and prosecution. What's important to know as well, which I'll reiterate later, war crimes have no statute of limitations. You can be prosecuted until before you pass away. They're still hunting Nazis. Can't believe some of them are that old, right? But that is some serious stuff with regard to war crimes. You don't want to mess with it. So the mandate of the Royal Commission of Inquiry is twofold. First, to provide evidence for the prosecution of perpetrators of war crimes committed in the Hawaiian Kingdom. Second, to use its war criminal reports as a deterrent in order to compel off officials of the state of Hawaii, and the counties to begin to comply with international humanitarian law and the law of occupation or face the same consequences of prosecution. There are no statute of limitations of war crimes, and if there is evidence that war crimes have been committed in the Hawaiian Islands with awareness that their acts are unlawful, the perpetrators will be prosecuted whether here or abroad. So let me give you some context. 1943, I'm in Paris, France. I'm a Frenchman. And I tell this SS officer, you committed a war crime. I got evidence on you. What does that SS officer do? Because they're in control. Ha! 2 years later, crash, 1945, Nuremberg trials. That is how serious things have to be taken with regard to war crimes. That's why Chabis was very important for his legal opinion. He would not have written a legal opinion on war crimes being committed in Hawaii if it wasn't true, otherwise he destroys his reputation at the international level. Now, the Royal Commission of Inquiry also published a book in 2020 that included chapters written by Professor Matthew Craven on the continuity of the Hawaiian Kingdom as a state, Professor William Chabis on war crimes being committed in the Hawaiian Kingdom, and Professor Lanzarini on human rights violations occurring in the Hawaiian Kingdom. And I also wrote two chapters and an intro. So I'm the editor of the book. Here's the book. Kind of thick. Yeah. So what's important is whenever you publish academic stuff, it goes through what is called a peer review process, right? And if it doesn't pass the peer review process, it doesn't get published. It's a scientific approach, right? When you publish a book, what can make or break it is a book review on it. 2022, faculty member, the University of Warsaw in Poland, Department of Political Science and International Studies, published the book review in the Polish Journal of Political Science on this book. I'm going to read some sections of it. The above main assumption of the book is emphasized from the beginning of Part 1, which is preceded by the text of the proclamation establishing the Royal Commission of Inquiry, recalling that the Commission was established to ensure a full and thorough investigation into the violations of international humanitarian law and human rights within the territorial jurisdiction of the Hawaiian Kingdom. In fact, the main aim of the above institution as called into being has been to pursue any and all offenses and violations in the spheres of humanitarian law, human rights, and war crimes committed by the Americans in the course of their occupation of Hawaii, which is given to have begun on 17 January 1893. Presented next is the genesis and history of the Commission's activity, described by its aforementioned head, Dr. David Keanu Sai. He presents the Commission's activity in detail by reference to concrete examples, with this part going on to recreate the entire history of the Hawaiian-U.S. relations, beginning with the first attempt of territorial annexation. This thread of the story is supported with examples and source texts relating to the recognition of the Hawaiian Kingdom by certain countries, in this case, the UK and France, taken as evidence of international regard for the integrity of statehood. Particularly noteworthy is the author's exceptionally scrupulous analysis of the history of Hawaii and its state sovereignty. No obvious flaws are to be found in the analysis presented. What I appreciate, I have a qualified person to actually review this and make the point. It's good to speak the language of another political scientist and international lawyer. Now, the book review ends with this. I regard this publication as an exceptionally valuable one that systematizes matters of the legal status of the Hawaiian Kingdom, taking up the key issues surrounding the often ignored topic of a difficult historical context occurring between Hawaii and the United States. The issue at stake here has been regenerated synthetically on multiple levels, because she also covered Shabis, Craven, and Lenzerini, with a penetrating analysis of the regulations and norms or rules in international law applying to Hawaii, starting from potential occupied territory status and moving through to multidimensional issues relating to both war crimes and human rights. This is one of the few books, if not the only book, to describe its subject matter so comprehensively and completely. I therefore see this work as being of exceptional value and considerable scientific importance. It may serve not only as an academic source, but also a professional source of knowledge for both practicing lawyers and historians dealing with the matter on the hand. The ambition of those who sought to take up this difficult topic can only be commended. So basically, this was a raving book review on that book. And when I got it, I smiled. I said, yes, somebody understands what we're saying. So, establishing a military government. So we're bringing it to a close, this presentation. Complying with the law of occupation, despite 131 years of violations, is to establish a military government, to administer the laws of the occupied state pursuant to Article 43 of the 1907 Hague Regulations and Article 64 of the 4th Geneva Convention. The United States' practice of establishing a military government is the responsibility of the U.S. Army. It is not the responsibility of the U.S. Navy, Marines, or Air Force. That is directly from U.S. Department of Defense Directive 5001.1. Okay. Military governors that preside over military government are general officers of the Army. Like in the case of Japan, MacArthur. In the case of Germany, Eisenhower. Now, what is the formula to determine who of the United States is responsible to establish the military government? It has to be the entity of the United States that is in effective control of territory. Because without being effective control, you cannot enforce anything. You have to have effective control, and that is according to Article 42 of the Hague Regulations. The federal government and its military is in effective control of 360 square miles of Hawaiian territory, which is only 3% of Hawaiian territory. The state of Hawaii, on the other hand, is in effective control of 11,000 square miles, which is 97% of Hawaiian territory. Consequently, the state of Hawaii is the occupant of the occupying state that is obligated to transfer itself into a military government. Now, October 10th, 2014, the Council of Regency proclaimed that the current laws of the federal, state, and county shall be the provisional laws of the Hawaiian Kingdom, so long as these laws do not run contrary to Hawaiian constitutional law. Because we got to provide the process by which to begin the transfer. Because to administer the laws of the occupied state, 1893, outdated. Got to bring it up to date. And I presented this at the last council presentation. Also, I presented to the council in 2019 that on June 3rd, 2019, the Regency also proclaimed that it recognizes the state of Hawaii and its counties as the administrative power of the occupied state. Okay. The state of Hawaii, however, did not transition into a military government. And that's what prompted my letter to the State of Hawaii Attorney General, Claire Connors. And that was dated June 2nd, 2020, from me as head of the Royal Commission of Inquiry. I stated that the Royal Commission sees as its priority the establishment of the military government in order to administer the laws of the occupied state, and thereby bringing the state of Hawaii and its counties into compliance with international humanitarian law. Members of the state of Hawaii and its counties are not the insurgents of 1893, but rather friends and family that found themselves in a tenuous situation without any fault of their own. Their actions viewed through the lens of international law, however, have led to the commission of war crimes against the civilian population who have been made aware of the prolonged occupation, and when they were asserting their rights, they were attacked. Okay, that's what was happening. Now, war crimes are being committed, but the awareness is not there yet. The mens rea. I'm establishing the mens rea with the State of Hawaii Attorney General. And then I end with, these are not normal times, but you are the legal advisor to the governor. And due to the severity of the situation under international criminal law and the material elements of mens rea, which is the guilty mind, and actus reus, the act of the crime itself, I respectfully implore you to carefully review the information I provided you and to advise the office of the governor accordingly. Under international humanitarian law, decisions on this matter are not with the federal government, nor is it with the military here in the islands, but solely on the shoulders of the state of Hawaii, as it is the entity in effective control of Hawaiian territory, thereby triggering the law of occupation. It should also be noted that the governmental infrastructure of the state of Hawaii is that of the Hawaiian Kingdom. The only change was in name. Example, the Department of Land and Natural Resources is actually the Ministry of the Interior. All that changed in 1893 was the Queen and her cabinet, and the top law enforcement officer of the kingdom, Marshal Charles Wilson, being forcibly replaced by insurgents calling themselves the Executive and Advisory Councils. Well, since that letter, nothing happened. Went on deaf ears. Well, that forced us to make the move. In November of 2022, the Royal Commission of Inquiry published 14 war criminal reports identifying the senior leadership of the United States, State of Hawaii, and county governments for the war crimes of usurpation of sovereignty during military occupation, deprivation of a fair and regular trial, and pillage. War Criminal Report number 22-0005 identifies David Ige, found guilty in the first degree of committing the war crime of usurpation of sovereignty, subject to prosecution. War Criminal Report 22-004 identified Michael Victorino and Alice Lee committed war crime of usurpation of sovereignty in the first degree. War Criminal Report 22-004-1 3 corporation council members that was advising Victorino and Alice Lee in a federal lawsuit that was filed because we were able to get the evidence of the war crimes in a federal lawsuit. So we had to make sure that the elements were met. So these are the elements that have to be fulfilled for usurpation of sovereignty. First, the perpetrator imposed or applied legislative or administrative measures of the occupying power going beyond those required by what is necessary for military purposes of the occupation. Number 2, the perpetrator was aware that the measures went beyond what was required for military purposes. Number 3, the conduct took place in the context of and was associated with an occupation resulting from an international armed conflict occupation. And the final one that gets to mens rea, the guilty mind, the perpetrator was aware of factual circumstances that established the existence of the armed conflict and the subsequent occupation. Evidence of the commission of these war crimes were retrieved from pleadings in a federal lawsuit, Hawaiian Kingdom versus Biden and others, that lasted from May 20th, 2021 until December 13th, 2022. That's the federal lawsuit that was filed. In its filed complaint, the Hawaiian Kingdom sought court orders to compel the United States and the state of Hawaii to begin to comply with the law of occupation and begin to establish a military government. However, In order for the federal court to have jurisdiction over this complaint, the Hawaiian Kingdom requested that the court transform itself into an Article II occupation court, which comes in history from Germany. Article II, U.S. Constitution, President, Commander-in-Chief of U.S. forces in occupied territory. So there is precedence to transform into an Article II occupation court. Right now it's operating as an Article III court, the American judiciary, but the judiciary is limited to U.S. territory. Cannot be applied here. On October 6, 2021, an amicus brief, or friend of the court brief, was filed by the International Association of Democratic Lawyers, the National Lawyers Guild, and the Water Protectors Legal Collective. So they actually filed an amicus with the federal court explaining that you need to transform yourself into an Article II court. And here's why. And these are coming from lawyers. Judge Ron Trader, the magistrate, accepted the amicus. So the amicus opened with, the purpose of this brief is to bring to the court's attention customary international law norms or rules and judicial precedent regarding Article II occupation courts that bear on the long-standing belligerent occupation of the Hawaiian Kingdom by the United States at issue in this case. In assessing the legality of the U.S. occupation of Hawaii, the court should be cognizant of customary international law and international human rights treaties that are incorporated into domestic law by virtue of Article 4, Section 2 of the Constitution, called the Supremacy Clause. The question here is not whether the Hawaiian Kingdom has standing in an Article 3 court. The question is whether the court can sit as an Article 2 court, occupation court, and whether the claims of the Hawaiian Kingdom can be redressed. The answer to both questions is yes. So this is not us making an issue of an occupation court. You're looking at experts outside that are trying to advise the court, you got to do this, because that's what the rules are. Well, the court, District Judge Kobayashi did not transform itself into an Article II occupation court in accordance with international law, and therefore consequently committed the war crime of depriving a person of a fair and regular trial. The court doesn't have jurisdiction. Neither the court nor defendants provided any rebuttable evidence to the Hawaiian Kingdom's continued existence under international law and the ensuing military occupation since 1893. At no point has anybody, whether legally or factually, disproved what we said and what we shown. Just not comply. In these proceedings, the defendants were made aware of the factual circumstances of the American occupation, mens rea, and that the imposition of American laws and administrative measures constitute the war crime of usurpation of sovereignty. In the filings, the court and the defendants admitted that the Hawaiian Islands were annexed by an American law, and the state of Hawaii was established by an American law. They argued that this case was a political question on jurisdictional grounds, which, by the way, is an American administrative measure limited to U.S. territory. They're using the war crime of usurpation of sovereignty as a defense. You know what they say, don't say anything if you're in court because it might be used against you. These are pleadings. In other words, the court and defendants admitted to the war crime of usurpation of sovereignty, but their conduct was, what are you going to do about it? The court and the defendants were fully aware that they were using American municipal laws and administrative measures, calling it a political question, in their attempt to have the complaint dismissed, which is the war crime of usurpation of sovereignty. The perpetrators met the elements of the war crimes and the requisite elements of mens rea awareness. After the war criminal reports were published, the Hawaiian Kingdom withdrew its amended complaint because it was unable to get relief from the defendants because they are alleged war criminals. And the court did not transform itself into a Article II occupation courts, and all those war criminal reports were actually made a part of the record. So they're on file in the federal court. All courts in Hawaii, both federal and state, are all under American law and are unlawful. In fact, that was the whole case that went to The Hague back in 1999. Now, every foreigner who visited the Hawaiian Islands had been victimized by the war crime of usurpation of sovereignty during military occupation when they were subjected to taxation by the American fiscal regime. The counties of the state of Hawaii have recently added 3% surcharges of the state of Hawaii's 10.25% transient accommodation tax on tourists. Added with the state of Hawaii general excise tax of 4% in addition to the 0.5 county general excise tax surcharges, civilians who are visiting the islands will be paying a total of 17.75% to the occupying power. That's all by virtue of usurpation of sovereignty. And their countries are supposed to prosecute war criminals if you come in their territory. Royal Commission of Inquiry is what provides the evidence for probable cause, for detainment, and prosecution. It is the duty of the Adjutant General of the State of Hawaii, Major General Hara, to transform the State of Hawaii into a military government in accordance with the law of occupation and Army regulations. That's the office. Not the person, Ken Hara, it's the office. And he's an Army General Officer. According to the U.S. Manual for Courts Martial, a duty may be imposed by treaty, statute, regulation, lawful order, standing operating procedure, or custom of the service. In this case, Major General Howard's duty is imposed upon him by Article 43 of the 1907 Hague Regulations. And U.S. Department of Defense Directive 5000.1, which states that it is the duty of the Army in occupied territories abroad to provide for the establishment of a military government pending the transfer of this responsibility to other authority. On April 17th, last year, I met with Major General Hara and John Enos at the Naniloa Hotel in Hilo. At this meeting, I provided Major General Hara the necessary and relevant information and resources of the American occupation and his duty to transform the state of Hawaii into a military government. I stated to him, though, that he had to do his own due diligence and not take my word for it. He needs to use his chain of command. So I recommended that he task his staff judge advocate, Lieutenant Colonel Lloyd Phelps, who's a Maui prosecutor, to go over the information I provided and to see if he could provide rebuttable evidence to show Major General Hara that the Hawaiian Kingdom does not exist. Very simple. Just so it doesn't exist. Because if he can't, then your duty is triggered. But I'm giving you that time frame to do it. Do your due diligence. We both agreed that he should have latitude and freedom to do his due diligence without any interference from me, and that we would be communicating through Mr. Enos as an interlocutor. That's how we're going to communicate. What's the status? How things are going? I was told by Mr. Enos that Major General Hara, on July 27, 2023, admitted the Hawaiian Kingdom continues to exist, which I took that his due diligence of 4 months was over. That's how long I provided him. Look into it. However, further communication was interrupted by the Lahaina wildfire on August 8th. Major General Hara has yet to comply with his duty and obligation under international law, which has consequently placed all state of Hawaii and county officials, like you folks, as potential war criminals. It's on him, because he's the one that has that duty, not anybody else. The war criminal tribunals in Nuremberg and Tokyo that followed the end of hostilities during World War II marked a clear recognition by the international community that all members of the chain of command who participate or acquiesce in war crimes must be individually held accountable. Criminal responsibility. Command responsibility arises when the military superior, during an occupation of a foreign state, fails to exercise sufficient control and accountability for his or her subordinates in the commission of war crimes. International law also recognizes that a non-military commander is also responsible for failing to stop war crimes, and that is what was on Governor Ige's duty. He didn't stop the commission of war crimes, but he had that opportunity too. Thus moved into, now he committed the crime himself. At first glance, it would appear that Major General Howard's failure to perform his duty is a crime under the Uniform Code of Military Justice and a war crime by omission under international law. We're still looking at the mens rea. And the Royal Commission of Inquiry is not going to pull that trigger yet because he has to do his job. He will force the Royal Commission of Inquiry to do that report. And then we move to the next level, Deputy Adjutant General. If there is any soldier or civilian advising Major General Howard to do otherwise, they would incur criminal culpability as an accomplice to the war crime of the war crime themselves. On October 17, 2023, I had a meeting with John Waihee, the former governor of Hawaii, and I explained to him the situation here and what he could do to help encourage Major General Howard to do what he's supposed to do, because he could not refute the Hawaiian Kingdom's existence. He admitted to it. Waihee tells me that he would advise Major General Howard not to transform the state of Hawaii into a military government because he would be committing treason, which is nonsense, because this is not America. Hawaii has a treason law. Applies here. America has a treason law. It applies there. Doesn't apply here. Treason law of America is, if it's imposed here, it's called usurpation of sovereignty. You're right back to square one. If John Waihee is advising Major General Howard of this, because I did hear that Major General Howard is concerned of treason. If in fact it was Waihee that was advising him of this, he will be considered as an accomplice to the war crime of omission. So you can see we're not playing games here. We've tried every opportunity to fix the problem, and it forced our hand to hold people accountable. And that's why the reputation of the Royal Commission of Inquiry was very important. Now, a soldier who is found guilty of willful dereliction of duty resulting in death or grievous bodily harm is subject to dishonorable discharge, forfeiture of all pay and allowances, and confinement for 2 years. Under Title 18, U.S. Code Section 2441, to get the idea of the punishment of a war crime, it states whoever, whether inside or outside of the United States, commits a war crime shall be fined under this title or imprisoned for life or any term of years or both, and if death results to the victim, shall also be subject to the penalty of death. These are serious issues, all connected through law and regulations. And most important, and in closing, in 2022, Germany prosecuted a war criminal, former concentration camp secretary, 97 years old, convicted of Nazi war crimes. That's 2022. So that's the severity of the situation. That is the update from 2019 of events that have taken place. And that the most important thing here is I believe that when decisions are made, it has to be informed. Informed decisions and making sure you start asking the right questions of the right people and not try to find something to get an excuse. We're past that now. We're past that. So I believe that what I presented to you folks, this is a long process when we started it back in 1997, but we've been on track with our strategy to move toward fixing the problem. And you need a military government here, okay, which is the state of Hawaii stays intact, right? But headed by a military governor, because you need command and control, centralized command and control that will cut through everything of all the politics, of all the bureaucracy, because that's all American law. And it has to bring the Hawaiian Kingdom, its governmental infrastructure, back in line with what it was before 1893, including its economy, including its currency, including its international trade. All that comes into play, and that is the job of a military governor, which is why you need centralized control. That's how it works. This is not a debatable issue. This is not democratic. And every military government established by the United States military in foreign countries was always established in a hostile situation. When General MacArthur became the military governor in Japan, do you think the Japanese loved him? To them, he was an enemy, but he was the military governor. When Eisenhower in Germany After the Nazis overthrown, you think he was welcome? No, he had command and control. And he brought issues of compliance when the occupation eventually ended. The same thing with Japan, and the same thing we have here. So there is precedence on these issues, and not just the rules and laws and regulations. And with that, I want to thank Councilmember Paulton for allowing me to give an update to the council from 2019. Mahalo.